Have you ever watched a courtroom drama and thought, no way that could happen in real life? Well, sometimes reality is even more unbelievable than fiction. Today we're diving into a story where a single, unexpected legal maneuver completely flipped a case on its head, leaving everyone in the courtroom, from the judge to the jury, absolutely stunned. This isn't just about legal jargon. It's about strategy, psychology, and the kind of high-stakes thinking that can win or lose a case in a single moment. Stick around because you're about to hear how one lawyer's brilliant, out-of-a-box move changed everything. Let's set the stage. The case seemed straightforward, almost a slam dunk for the prosecution. They had a mountain of evidence against the defendant, a man accused of a complex financial crime. We're talking about documents, emails, witness testimony, the works. The prosecution had spent weeks meticulously building their case, brick by brick, creating what looked like an impenetrable fortress. The defense attorney, on the other hand, seemed to be struggling. He was chipping away at the evidence, cross-examining witnesses, but nothing seemed to land a significant blow. The mood in the courtroom was heavy. You could feel the weight of the evidence pressing down, and it looked like a guilty verdict was almost a certainty. The defendant's face was a mask of despair, and his lawyer looked increasingly frustrated. The prosecution's star witness was on the stand. This was the person whose testimony was meant to tie everything together. He was a former business partner of the defendant, and his story was compelling, detailed, and damning. He spoke with confidence, outlining a timeline of events that painted the defendant as a calculated and deceptive mastermind. The prosecutor guided him through his testimony, and with each answer, another nail seemed to be hammered into the defendant's coffin. The jury was captivated, hanging on every word. The defense lawyer's cross-examination began, and it followed the expected pattern. He questioned the witness's memory, his motives, his relationship with the defendant. But the witness was well prepared. He parried every question with a calm, credible answer. The defense seemed to be getting nowhere, and you could see the jury's belief in the witness solidifying. Then, just as the cross-examination seemed to be winding down, the defense lawyer paused. He took a slow breath, walked back to his table, and picked up a single, unassuming document. It wasn't part of the mountain of evidence the prosecution had presented. It was something new. The courtroom fell silent. The lawyer approached the witness stand and said, "I have just one more thing for you to look at." He handed the document to the witness. The witness glanced at it, and for the first time, his composure cracked. A flicker of confusion, then panic crossed his face. He looked at the lawyer, then back at the paper, his confidence visibly draining away. The prosecutor, sensing a shift, stood up to object, demanding to know what the document was. This is where the genius of the move comes in. The document itself was actually irrelevant to the case. It was an old, completely unrelated business filing from a decade prior that had the witness's signature on it. It had no bearing on the financial crime being discussed. So why did it cause such a dramatic reaction? The defense lawyer's entire strategy wasn't about the document itself, but about the asterisk implication asterisk of the document. He had laid a psychological trap. For presenting the paper, he had spent the last hour of his cross-examination subtly planting seeds of doubt about the witness's memory and attention, to detail asking seemingly minor questions about dates, times, and specific phrases used in old emails. They seemed like pointless questions at the time, but he was setting the stage. Now, with everyone's attention fixed on this mysterious new paper, the lawyer calmly asked the witness, "Is that your signature on the bottom of that document?" The witness, flustered, admitted it was. The lawyer then asked, "And do you remember signing this document on the date specified?" The witness hesitated. His mind was racing. What was this? What did it prove? He couldn't remember signing it. He'd signed thousands of documents in his career. His carefully constructed image of having a perfect, infallible memory was suddenly under threat. He stammered, I'm not sure. I don't recall this specific document, and that was the moment everything changed. The lawyer didn't press him on what the document was. He didn't need to. I simply turned to the jury and said no further questions. The impact was immediate and devastating for the prosecution. The jury saw their star witness, a man who had just spent hours recounting minute details of events from years ago with absolute certainty, suddenly unable to remember signing a document with his own name on it. It didn't matter what the document was. What mattered was the doubt. If he couldn't remember this, What else might he not be remembering correctly? Were the details of his testimony really as accurate as he claimed? The foundation of the prosecution's case, which was built almost entirely on this witness's credibility, had just been fractured. The lawyer hadn't disproven a single piece of evidence. He had simply disproven the reliability of the person presenting it. This legal strategy is a masterclass in what's known as impeachment by contradiction, but with a psychological twist. Usually, lawyers use prior inconsistent statements to impeach a witness. But here the lawyer used a non-event, the witness's failure to recall something, to create a powerful contradiction. The witness's entire persona was that of a man with a photographic memory, and the lawyer showed the jury that this persona was a facade. He knew he couldn't win by fighting the evidence directly, so he attacked the source. He created a moment of high drama and uncertainty that would stick in the jurors' minds far more than any dry analysis of financial records. He turned the prosecution's greatest strength, their star witness, into their biggest liability. In the aftermath, the prosecutor tried to recover during their redirect examination, attempting to downplay the significance of the moment. They tried to explain that it's normal not to remember every single document you've ever signed, but the damage was done. The seed of doubt had been planted, and it was growing. The jury's perception of the witness had been permanently altered. They were no longer looking at a credible source of information. They were looking at a flawed, potentially unreliable narrator. The defense lawyer, in his closing argument, barely mentioned the financial evidence. Instead, he focused almost entirely on that one moment, reminding the jury over and over, if you can't trust the messenger, can you really trust the message? So, what happened in the end? The jury deliberated for 3 days. The length of the deliberation itself was a victory for the defense, proving the case was no longer the slam dunk it once seemed. Finally, they returned with a verdict: not guilty. A case that had been built on a mountain of evidence crumbled because of one piece of paper in a single, brilliantly timed question. It wasn't about finding a smoking gun. It was about creating a shadow of doubt so large that it obscured everything else. This story is a powerful reminder that in a courtroom, a trial is not just a presentation of facts. It's a battle of narratives, a contest of credibility. And sometimes, the most effective weapon isn't a piece of evidence, but a deep understanding of human psychology. It shows that with the right strategy, one sudden move can truly change everything. What do you think? Is this a brilliant legal tactic or a cheap trick? Let me know your thoughts down in the comments. And if you enjoy stories about strategy and psychology from the real world, make sure to hit that like button and subscribe for more content just like this. Thanks for watching, and I'll see you in the next video.